Hello, guys. So today, I guess I've been doing them all on the same day, but today we're also going to talk about Article 3 of the Constitution. So we touched on Article 1, Article 2, and we also talked about some of the articles in the Unit 1 video of Federalism. But now we're going to focus our attention to Article 3, which establishes the judicial branch. And one thing you'll notice with Article 1, Article 2, and Article 3 is they get progressively shorter. A lot of people think, well, the framers are probably kind of tiring out. I mean, that's one opinion, or they wanted the Supreme Court to kind of maybe decide what their own independence meant over time. So, in Article 3, it establishes that Congress has the ability to establish all inferior courts. And it has the ability to decide how many justices will serve on the Supreme Court. It can also alter the Supreme Court's appellate jurisdiction, but not its overall jurisdiction. Its appellate jurisdiction is its ability to hear cases from the lower courts. So, say that someone lost a case in the lower court and they want to appeal it to the Supreme Court. Well, Congress can pass something to limit that appellate jurisdiction, so perhaps the Supreme Court may not be able to hear that case. And we'll see some interesting examples about how jurisdiction comes to play into Marbury versus Madison. But another important thing to note about the Supreme Court is that it guarantees judicial independence and kind of keeps the judicial branch isolated from the pressures of the national constituency and its other branches that serve as counterparts. So the Supreme Court the members are granted lifelong terms, and Congress cannot readjust their salaries, so they can't be bribed by Congress to make a certain decision based on monetary influences. So, as we mentioned, the Supreme Court has 9 justices today, but originally 150 years ago it was actually at 6 justices. And there was an instance in about, I think it was 1939, where FDR decided to have this court packing plan where he wanted to alter the justices from 9 to 15 because the Supreme Court wouldn't do his bidding. They wouldn't let him get those important Great Depression federal aid programs going that he needed to. So his idea was, well, I could stack the courts. The Congress never ended up approving of this, but the Supreme Court became a little more fearful of FDR and started kind of allowing him to do some stuff. So I'll get more into how government officials and other branches can influence the judicial branch, though. But as you mentioned, that's probably the gist of the Supreme Court there. And we also mentioned inferior courts. So you have like trial courts, courts of appeals, district courts, federal tribunals, that kind of thing. Um, and there's also like subdivisions of federal courts, like federal circuit courts and all that good stuff. But Congress is responsible for creating these courts and managing their operations. So Congress can kind of control these courts through funding. So these guys are a little bit more subjected to popular authority than the immune Supreme Court. But I guess I can't even call it immune because we'll get to that. All right, so talked a little bit about this idea of judicial independence. It's the fact that the judicial branch is isolated in the sense that they have lifelong terms, so they're not tied to a national constituency, and their salary is consistent. So now I'm going to take you into this landmark case called Marbury versus Madison. So you can skip my explanation on this if you so choose to, because I'm about to give you a little bit of a historical background. And then I'll summarize it if you'd rather just skip that and hear that. But back in the election of 1800, we had John Adams, who was the incumbent, pitted against his actual former vice president, Thomas Jefferson. Now, to speed things up, Thomas Jefferson ended up winning this election. Okay? So now I'm going to also do a really awkward flashback here. So I guess it's kind of a flash forward. It's weird. But once the Adams administration had found out Jefferson had won the presidency, the Adams administration started mass creating a bunch of uh, justice, like justice programs almost. Like they were, I guess you could say, you could call them uh, like judiciary posts, I guess, for lack of a better term. I'm trying to think of something better to put that as, but they're basically judicial positions that the Federalist Congress under the Adams administration started just creating all over the place, because they were worried that because Thomas Jefferson was a Democratic Republican, that when Thomas Jefferson got in there, he would start filling up those other judicial posts with people that followed his philosophy. So they kind of wanted to insulate that. And so they had these infamous midnight judges or whatever. And one person who was supposed to be one of those uh, justices of the peace, was a man by the name of William Marbury. And so basically, John Marshall was Secretary of State at the time, and he just let Marbury's commissions sit on his desk because he didn't have time to get to all of these commission deliveries with all the corrupt things going on in the background. He just didn't have time. And so that left it up to the Jefferson administration to deliver Marbury his commission. But the Jefferson administration wasn't about to put a Federalist into office if they could avoid it. So Secretary of State Madison decided that he wasn't going to deliver the commission. And so we're going to see something really strange happen here. So Marbury challenges Madison in the Supreme Court. So he basically, this like almost never happens. He was like, we're just going to challenge you in the Supreme Court. But he did this because there was a statute predating that said that for cases such as his, he would be allowed to appeal right to the Supreme Court. So the first thing the Supreme Court considered was, my apologies, someone is texting me. That's an awkward transition now. But he had to consider two main things. Does the Supreme Court have a right to issue a writ of mandamus? And a writ of mandamus is this authority that the Supreme Court would place on another official to get something done that they're supposed to. And he decided that yes, he could. And he essentially decided that Marbury was entitled to his commission. However, Marbury lost the case because the Supreme Court overturned that statute that gave the Supreme Court original jurisdiction, because they ruled it as unconstitutional. So because the statute that Marbury used to appeal to the Supreme Court was in fact unconstitutional, then the case could not be heard. Therefore, Marbury could not have his commission. And so, as much as this sucked for Marbury, this established the new principle of judicial review, and this was something actually foreshadowed in Federalist 78, written by Hamilton, that we'll get to. So this idea of judicial review is such that the Supreme Court can review previous pieces of legislation and determine whether or not they are constitutional or unconstitutional, and they can use that as a check on other branches, so they can determine whether those actions are constitutional or unconstitutional. So that's kind of the long version of the Marbury Madison case, but I believe personally the history is very interesting. All right, so we talked about judicial review right there, and you can look into John Marshall himself. He was Secretary of State in the Adams administration, and then he was the Chief Justice, presiding ironically over the Marbury versus Madison case. But he became known that despite the fact he was a Federalist, he made very nonpartisan choices, and his concept was to unify the Supreme Court with the Constitution, and then that Constitution could be unified with the people. So he lived by that, and he became famous for his landmark decisions. So, as I mentioned, I talked about Federalist number 78. And in this, Hamilton decides that he basically lays out what the judicial branch should look like. So he establishes what judicial independence would mean, as we talked about, through the installation of lifelong terms and consistent salaries. And he even predicted judicial review through this statement here. And you can go and read Federalist number 78, but you want to just recognize these key ideas here. But I think it's also important to look at this quote, neither purse nor sword. Misclick there, that's fun. But what he meant by neither purse nor sword is that the judicial branch was supposed to be weaker than the other two branches because it could not tax and it could not deploy a military, it could not enforce its decisions. So it was basically harmless. Its job was to interpret the law and wait for the executive branch to carry it out. All right, so I think you should take some serious note of this because if you're analyzing the origins of the different branches in comparison to what the framers wanted and what they became, it's always important to start with the Federalist Papers. All right, so now we're going to talk about the legitimacy of the judicial branch. A lot of times when the judicial branch takes up controversial cases, the Republic loses respect for them. And they question the judicial branch, do you have jurisdiction in those cases? Now, the judicial branch establishes its legitimacy by this idea of continuity. So the stare decisis. I can't speak today. It's been a long day. You get the idea. But this term here, this Latin word means let the decision stand. And yeah, that's true, John. Let's be honest, that's true. But it's basically the idea that past legal decisions serve as precedents to current cases. So it's the idea of this continuity. If you have a similar case in the past that set a precedent, you are going to use that same case to justify your actions for choosing the same decision in the current times. Now, I apologize. Someone just keeps texting me. I don't know if you can hear that in the background. I'm gonna actually handle that real quick so that it stops occurring. Oh, it's Rory. Rory, I want you to know that you ruined my video. I love you though. Alrighty, my apologies, guys. I would cut that out of the video, but I honestly don't have emotional time to at this point. So thank you, Rory. Thank you for texting me. So as we were talking about precedents, that's something, a legal decision in the past that sets a rule, essentially, for decisions on similar cases in the future. And as we talked about this life tenure concept, that means that the Supreme Court justices hold their terms for life. So it gets a little redundant here, but this concept is very important for insulating them. All right, so we're going to talk about the court in action. Now, I'm not going to go too in depth on this one, but there's a variety of strategies that you'll see kind of carry over here where you can curb the power of the Supreme Court. And these are called court curbing measures. And so these strategies reduce the power of the Supreme Court or weaken the impact of its ruling. So say you have the executive, they can choose not to follow the ruling if they don't like it. That you could have a Congress that would pass other legislation to lessen the impact of this decision. So that is the whole idea of implementation. The presidents may enforce the rulings, but they also may not. So currently, a lot of them see it as their duty to protect the Constitution. But there have been instances in history, such as the Embargo Act, where For instance, President Jefferson just kind of kept doing what he wanted, regardless of the fact that the Supreme Court ruled it unconstitutional. And this key idea of jurisdiction that I mentioned, hopefully you understand that that's just the extent to which courts can oversee cases. All right, so this whole idea and the way the Supreme Court decides on things, the cases that they take will determine public trust and willingness. So, currently in our society, the Supreme Court is heralded as something that upholds the Constitution because of the way they have handled cases in the past, and that has established their legitimacy. Now, you can also skip this part if you're like, yeah, I know what the 19th Amendment is. I don't want to hear you blabber on about it. But I really want to talk about this one because it's really interesting. There was a case that was called Minor versus Happersett. And in this case, Virginia Minor wanted to vote because with the 14th Amendment, it said that citizens are entitled to vote under the Equal Protection Clause. Each person gets to vote. Well, technically it's the immunities clause, but it's within the 14th Amendment. So in this, Virginia Minor said, "All right, I'm going to register to vote because it clearly says I can vote." And so she goes to register and she's denied and she is furious. So she takes this case to the lower court and it works its way up to the Supreme Court, and eventually the Supreme Court, being misogynistic at the time and following societal norms of the time, says, well, no, this doesn't extend to women, even though technically she is a citizen. So basically, it set the precedent that women could not vote. Now, that was prior to the 20th century. Moving into the 20th century, we saw a mobilization for women's rights, and that was embodied in the 19th Amendment, where citizens could vote regardless of gender. So just a little bit of an interesting background that I guess you could skip, but I found it interesting. And so, as you see here, we talk about checks on the judicial branch. The president has a power over the Supreme Court justice system because they're in charge of appointing the justices. So they can appoint people based on their ideological preferences in the hope that they might swing the court conservative or liberal. And quite similarly, the Senate can refuse to appoint someone to the bench if they so deem necessary. If they oppose the president, they might reject that appointment. So that's kind of more of a Senate confirmation check on the president as well as the judicial branch. All right, so we also have these two different ideas that we even see today. So judicial activism, we a lot of times see in liberal justices, and judicial restraint we often see in conservatives who want to follow the Constitution and not deviate from it. But in judicial activism, that is where the Supreme Court justice will use their own interpretation of the Constitution and their ideological beliefs in terms of doing what's best for the time period to make a decision. But with judicial restraint, that's just more where the Supreme Court justice might be more inclined to redirect policy-making decisions to the other elected branches of government, and they stick to a narrow interpretation of the Bill of Rights. So when they're interpreting the Bill of Rights, they read it quite literally. They don't look at it in the flexible way that the judicial activists might. And so that's going to conclude that video. Next up is the bureaucracy, and that's where things get a little bit interesting because you're going to see how this technically is a fourth branch of government that kind of goes under the radar. And so I hope that all of that helps you understand more of what our judicial system looks like. And once again, I apologize for all of my distractions during this, but I am so exhausted that I'm not going to re-record it. So, and I could cut the stuff out, but I don't feel like editing right now. So, my apologies. So, I'm going to take you to my Quizlet now that it's been updated with all of the judicial terms, and there's even additional information in there if you want to kind of beef up your essay or you find it interesting. So now we're at 301 terms. I promise you, it's actually really succinct. It goes fast. And I'd like you to just take a look at it on your own time, because I truly believe it can help you reinforce what I'm talking about, because I'm going through things really fast. So a lot of this is quiz questions, but you will also learn some very interesting things about the court packing plan. There's also the Southern Manifesto. You'll learn some court cases. We'll go over Plessy versus Ferguson and that. We'll go over Brown versus Board of Education and a couple other landmark Supreme Court cases you will learn about in this video that I just didn't want to spend too much time on because for the sake of your time. So I'm going to move on to working on the bureaucracy. I believe that will be done sometime late tonight or into tomorrow morning. And then I will get on to finishing civil rights and civil liberties. And so I hope this helps you. If you have any questions, like I said, feel free to ask, but not while I'm making a video, Rory. So I love you guys and I miss you, and it's been like forever since I've seen you, and also it's been forever since I've taken this class. So hopefully I didn't say anything stupid or historically inaccurate, but I hope this helped a little bit. So I'll see you guys in the next video.